Nevada and Hamilton.
Morning, Mr. Attorney. We've looked at the papers, obviously, as you would expect, and we've read the very helpful cases, and it's a pretty short point, although it's been elaborated. Unless you felt there was anything that you wanted to add to your written case, which seems to us to put your position very clearly, we were minded to think that we could perhaps call first on the respondent. The consequence would, of course, be that the respondent had the last word. You would have a right to respond, and then there would be a right of reply. So that is one consequence I draw to your attention. But as I say, it's up to you. If there is nothing you wish really to add to your written case, we will go straight to the respondent.
My Lord, I'm extremely grateful for that indication. And perhaps before I begin with the formalities, may I say simply one point, that to refine our written case to this extent, that where we have submitted that there is a complete discretion, we do submit that in fact that discretion is qualified by the duty, and as we have already submitted within our written case, we submit that the reading and the meaning of Section 7, subsection 2 of the Code might potentially, preferably be one where the word "and" is to be read as a "but." So, my Lords, that would result in a reading where the Section 7.2 of the Code, my Lords have
any
the point.
but.
My Lord, yes.
You shall refer some.
My Lord, yes. It's a simple point. We simply refine the suggestion to, we say, resolve what might be said to be a logical tension between a discretion to refer all and a duty to refer some. We accept there is potentially a logical tension, and to the extent that the board considers it necessary, we say that the preferable way of resolving that tension is simply to read the section in that manner, and my Lord has the rest of the points in effect from our written case. And my Lords, I don't, given your Lordship's very kind indication, I don't intend to go back through those, but will, of course, reserve my position for the reply.
Yes, well, we thought it would be helpful, probably, to understand how the case is put by the respondent, and you'll have a chance to respond to it. And so,
my Lord, I'm extremely grateful. I perhaps should deal with the formalities and simply to say, my Lords, I appear for the appellant together with my learned friends, Mr. Oliver Powell and Miss Mary Haskin. My learned friends, Mr. Nanya Small-Davis and Mr. Kentish appear for the respondent.
yes.
I'm very grateful.
And I would deal with the formalities and ask whether Mr. Powell wishes to add anything.
No, my Lordship.
Yes. Right, Mr. Kentish. Miss Kentish, I do apologise.
No, it's Tananya Small-Davis, my Lords.
Yes. What we really would like is then for you to help us as to the construction of this clause and help us as to how you put it, in the light perhaps also the way the courts below put it, but the real question is how you put it.
Yes, my Lords. I'm grateful. I think what I would like to do with your leaves is to do a sort of catch-up by way of two background points which I think might be relevant. Of course, the issue is the construction of Section 7.2 of the Code of Discipline that is made by regulations under the Prison Act of Anguilla. The Court of Appeal dismissed the appeal and held and construed the clause to say that the superintendent shall refer certain charges and that he shall not refer what the appellants have throughout referred to as the Class B offences, those being ones which are lesser offences under the code.
I mean, the real trouble is that there's no reference to shall not in the language.
No, there's no reference to shall not, but it's sort of construed as the flip side. If he shall do these, then he shall not refer these.
Well, just tell us, first of all, looking at the language, it has two parts. The second part is the part which I think is common ground, that he shall refer certain serious charges. We can call them serious charges, or we can call them Part A charges, or Type A charges, right? But how do you read the first part, which is the critical part, which you say the Court of Appeal construed as meaning that he shall not refer non-serious charges? Just read it grammatically from the language of the section, excluding the other bit. We start with the words, the superintendent may, after hearing the evidence, refer any charge to the governor. Then you must leave out everything on your case in the middle, mustn't you?
Yes, my lord.
May refer any charge to the government other than the following sections.
Other than the following sections.
Well, does that make sense?
Well,
refer a charge other than sections. Doesn't strike one as very grammatical.
no, but as it is, when you read this clause with respect, it appears to me that it is not at all grammatical in either interpretation that is contended for. It is very much an ambiguous and inelegantly drafted section, and I think that is what has posed the difficulties where two levels of courts in Anguilla have had difficulty with interpreting it in the manner in which the appellant contends for. We say that as it stands, the superintendent may, and it has in the bracketed words, after hearing the evidence, refer any charge to the governor, and the "and" is somewhat confusing, followed by the words, unless he dismisses it, which I think further confuses matters to the extent which, is it possible that he may refer a charge even if he dismisses it? It's quite strange. Those words seem to me to be completely unnecessary. And therefore, it causes you to have some doubt as to just how reliable, using a literal interpretation.
Well, it's already said in 7.1 that the superintendent may dismiss any charge. So in 7.2, I suppose the failure to include expressly the phrase unless he dismisses it in the first part may be more readily understandable, since the first part simply echoes the subsection 7.1.
Well, because 1 already states that the superintendent may dismiss any charge, and it seems to me to have been totally unnecessary, and to have included the words unless he dismisses it, because inclusion of those words suggests that the superintendent may, even though he dismisses a charge, may nevertheless refer it to the governor.
Well, I can see that, but I've suggested a possible reason. But anyway, what on your case does, how do you get what my lord mentioned, namely a requirement out of the word may? Because you're saying that may, after hearing the evidence, referring to charge to the governor other than under the less serious sections, means shall not refer a charge under the less serious sections.
Well,
and I mean, the difficulty with that is that the clause on your interpretation deals with two extremes. It deals with serious charges which must be referred, and non-serious charges which must not be referred. One would have thought that that's a slightly strange scheme for a legislator. Wouldn't a legislator be more likely to say serious charges must be referred, non-serious charges may be referred because they may, in combination, be sufficiently, or against a background of history, be sufficiently serious to go up to be dealt with by the governor, or they may not. So there's discretion. To deprive the superintendent of the possibility of referring seems rather strange.
Well, the difficulty is, my lord, that I start from a position of reading this section, which is not at all clear upon a first or perhaps even a second reading, and then turning to the what is the intent, trying to ascertain what is the intent of the Parliament, the legislature, in putting in place this code of discipline.
Yes.
It was to ensure that officers have a code of discipline, which the superintendent is charged with ensuring there is compliance and has a duty to enforce that code of discipline against his officers if it arises. If the superintendent is at liberty to refer any and all charges, which is the scheme contended for by the appellants, then it would make a nonsense of his own powers.
No, but nobody suggests that. Nobody
It
suggests
is
that the
being
superintendent has a duty to refer any and all charges. The suggestion is that the superintendent may, if he thinks it appropriate, or she thinks it appropriate, refer non-serious charges, and must refer serious charges. And your interpretation that the words means may not refer non-serious charges and must refer serious charges doesn't seem to correspond to the way the section is formulated. That's
Taking it from the point of view that this is a code of discipline which is completely self-contained, the superintendent has no powers outside of what is set out in the code.
right.
There is nothing in the code that speaks to his ability, what should influence this discretion, and his ability to consider that these are more, even though it is charged under less serious sections, that it's sufficiently serious that it should be passed up to the governor. In circumstances where, for example, by analogy, if you look at the same prison regulations, which particularly section in the Prison Act, in the Prison Act, for example, it's at page 592, section 34 of the prison regulations. This, my lords,
Wait a minute.
I'm sorry,
Sorry, which,
592, that seems...
592 of the electronic pagination.
Wait a minute.
where is it in hard copy? Do you know?
Yes, right.
57 in hard copy, my lord.
57. These are the...
592 is tab 5, yes. What internal page? Which number is it?
Section 34, Regulation 34. Just by way of analogy, my lord, where the argument is being advanced on behalf of the appellants, that in cases where, for example, the offence is, there are repeat offences, it's a repeat offender, or there's a cumulative number of offences which make it more serious.
I'm sorry,
Wait a minute, there isn't a section 34.
Regulation 34, it's on page, the hard copy is page 57, my lord,
57, yeah.
and 592 in the electronic bundle.
592.
First, the visiting committee.
Tab 4, page 57. Yes.
No, it's...
Tab 4, 57.
Tab 4, yeah. That's the regulation.
The
We've actually got a
regulation.
new copy of the regulations, but they're not different in this.
They're not different
So
in this
you
respect.
said regulation 30?
34, that's 586.
All right, it's 586. All right.
Is it?
Referrals to visiting committee, is that the one you want?
Yes, that's the one, my
That's
lord.
586.
Yeah. So the point I'm trying
Wait a
to,
minute. What do we find about this? We don't find any guidance as to the circumstances in which the superintendent may refer the charge. That
Well, it does. In 34.1, is that what you're getting at, where the
that's
powers
what
may
I'm
be
getting
inadequate?
at. That's what I'm getting at.
I follow.
So that,
So it's 34.1.
Yes.
Yes.
That's the guidance.
But I mean, I suppose there might there be other situations, quite apart from the inadequacy of the superintendent's sentencing powers,
Yes.
might there be other reasons why it would be sensible for him to have the power to refer the charge up for hearing?
I don't know, perhaps. However,
Supposing he was a witness himself, for example.
no. If he was a witness himself, I think that would be an obvious case and he would have to recuse himself.
So then what would he do?
Then I don't believe although there's powers of delegation to the superintendent, it's not clear that he could delegate this particular role, and that the natural thing would be a special case to be referred to the governor.
Well, how could you do that if your construction of Regulation 7 is correct?
Because of the specific and clear example that your lordship has pointed out, which I think is quite an apt one. However,
but wait a minute. How do you, if that specific example falls within the language, then it means that there is some discretion to refer charges to the governor in some circumstances.
No, I don't think that it falls within the language, but I think from a common sense and practical approach that he could not deal with it himself. He could not, in those circumstances, deal with it
Is
himself.
there any other power to refer apart from Regulation 7?
No, my lords, I have not been able to.
I'm just thinking about it from the legislator's, or rather the regulation drafter's point of view, because I take your point that there's nothing in the code which says how the discretion, if it exists, ought to be exercised. On the other hand, once you start defining how a discretion is to be exercised, you tend to leave something out, don't you?
Yes, my lord. But then we also have to bear in mind the context that this is not a judicial officer, and therefore ought to have been given some guidance, and it ought to have been made clear to him and to the officers which he is intended to superintend what the ambit of that discretion may be.
Right. Yes.
I think also, my lord, that in connection with the referral, now in the code at section 10,
Yes.
it sets out what the superintendent is to do when he refers a charge to the governor. Mm-hmm. He shall forward an explanatory statement.
Sorry, which page are you on now?
I'm so sorry, my lord. It
67.
is.
67.
Is it 67? I have it as.
Yeah. 67 of the hard copy.
Thank you.
Tab 5, 67, just after code,
Yep.
paragraph 7.
So I'm looking now at section 10, where a charge is referred to the governor under section 7.2 of this code. The superintendent shall forward an explanatory statement and also the record of the proceedings taken under section 5.1, together with all statements taken into consideration during the proceedings at the hearing. He is therefore to forward an explanatory statement.
Yes.
No doubt explaining why he's referring the matter to the governor.
But why do you need an explanation? Because on your case, there's no discretion. He has to refer serious charges, so there's no explanation necessary, and he can't refer any others.
Well, that is what we say is a further ambiguity.
Well, it's not ambiguity. What is he explaining?
Or illogical consequence of the code as it has been set out.
Well, that's only on the hypothesis that your construction is correct.
Well,
I think the problem is this, is it not? On your construction, he may not refer any minor charges to the governor, notwithstanding that the accumulation of those charges may be far more serious and egregious than a single offence which, on your construction, must be referred. That seems to be totally incongruous. How could the drafters of the regulation have contemplated the circumstance that several charges, which taken in combination would reveal a far more serious breach than a single charge, could not be referred to the governor? That seems a difficult position to accept.
well, that may be so, my lord. But if we look specifically at this case, where what has been referred, what was sent on to the governor, and I'm not sure, it does not identify that it is in fact the explanatory statement that is referred to, but at page 52 of the bundle.
Is that electronic? Sorry to
Of the record.
vex you with, is that the electronic one?
No, electronic is 55, my lord.
And non-electronic?
52.
Ah, it says the governing that, yes.
Very soon we will all
Tab
be
3, page
electronically.
52, CG1.
CG1. Thank you, my lord.
Letter of the 31st of December, is
The
it?
letter of 31st of December.
Thank you.
Now, just by way of a little bit of background, so you understand the context of what I'm saying here, the superintendent heard the charges, conducted a hearing. He dismissed one. The one that he dismissed is the one that you see at page 51, immediately before the letter that I've just referred you to. It's marked CG3.
That's the one dismissed, is it?
That's the one that's been dismissed
By the superintendent?
by the superintendent after the hearing.
Thank you.
That charge is that you, Neville Hamilton, was neglectful in your duties in lack of management and leadership on security standards and procedures contrary to section 41, 2D1 of the Code of Discipline.
Yes.
That, to answer my Lord Carr's point,
What you're going to say is this looks rather like the sort of charge which is the explanation for the reference given in the letter.
well, having dismissed that charge, it's difficult to see how a reliance can properly be placed on there being circumstances of this case that the cumulative effect of the other charges which have to do with
But that's a different point from the question of construction.
no, it is. I agree that it is, my lord, but I
And
think
that's not a point that's ever been taken to date.
But there were lots of other charges under section 2D1. I'm just trying to find where the charges actually are, but all the other ones seem to have been under section 2D1, so...
they all have been, they all were under section 2D1, save for one.
The mere fact that they must have had some particulars, and this...
They are in the bundle, my lord. I can direct you to them. They are at, the charges are at, copies of the charges are at pages 29, I'm sorry, 27, 30 of the electronic bundle, through to page,
And I think the problem is that, as my lord points out, we aren't here on a question of rationality. We're here on a question of law, whether there was power to do it in any circumstances. And so to examine the specific charges and to try and point out oddities about the ones which were dismissed and the ones which were accepted and so on is not going to actually help you, because we're not on that point. We're here on a pure question of law.
only to the extent, my lord, with respect that if reliance is being placed and it is found to be properly placed on the fact that there may be circumstances in which, although there are class B or lesser offences, the superintendent properly exercises his discretion in referring those to the governor. When we look at the broadest section, the broadest charge, which could be the one that addresses this conduct or pattern of behavior on the part of Mr. Hamilton, that charge was dismissed.
No,
And
I mean, you're descending into a specific complaint about the specific facts of this case, and I don't think that's the issue on which the case is before us or has been fought. If I'm wrong, you'll no doubt show me, but I don't see any reference to this in the judgments below or I think in your notice of appeal.
No, it's not been addressed in the judgments below. It was purely a matter of construction, and I accept that guidance. However,
As a matter of interest, why do you say that the charge on page 51 is, as it were, the most far-reaching of the charges?
because of the argument that is being presented as a basis upon which the superintendent could properly refer lesser charges to the governor.
But your case, as I understand it, is here we are, here is the most serious charge, he's dismissed that, so that puts an end to the argument that the others could possibly have justified referral. Now, even just supposing you're in a position to raise that argument, and I do see the difficulty that you may not be, why do you say that page 51 is plainly the most serious of the charges?
Well, I look at it together with the letter which immediately follows it
Yeah.
by the superintendent to the governor, and that is a letter which is now sent to the governor with the charges as a cover for the referral. And in it, he relies on, if we are to understand at all the basis upon which he would have exercised his discretion, if it exists, is that his reporting that the deputy superintendent has failed in his duties. He has a leading role in ensuring the smooth and safe running of the prison, but there is an absolute lack of confidence in his ability to perform at an acceptable level. And the support that he ought to give to the superintendent is lacking.
Well, it says, first of all, in paragraph 3, that his productivity is questionable.
Yes.
In paragraph 4, that there's a lack of consistency, and secondly, that he failed to accept his weakness, and thirdly, that he ignored advice to improve his performance. Those seem to be the generality of the complaints, but why are they particularly linked to the charge on the previous page?
Because
Look at the one on the page before that,
Yes.
page 50.
Part of the trouble is there are no particulars of these charges, so we don't really know what the charges
Or
really
49,
are.
I mean, consistently ignoring advice on important security issues, page 50, or disobeying a lawful order on page 49. Those are very serious, and they're more serious than a lack of management and leadership, one would have thought.
Well,
Because they have to be deliberate.
Well, I came to a different conclusion, my lords, that in fact this one, which is exhibited as CG3, was a sort of umbrella charge relating to his conduct as a whole, and that these other ones were just matters that would have contributed to that. So having looked at his conduct as a whole, the superintendent himself dismissed the charges, not finding that they had been made out that he has any lack of management and leadership. It's completely inconsistent.
So where do you get that distinction from? I mean, the trouble is that we've got very little material here.
Well, that is part of the trouble. We've not seen it. It was never before any of the courts.
Yeah.
But it goes to the heart of the question of my point, which is that the code is completely self-contained. Whatever powers that the superintendent exercises must fall specifically within this power, within the ambits of the code. If the legislature...
That's back to whether shall not should be implied into the
Yes.
section somewhere.
Yes. And therefore, if there was an intention that he could refer any and all charges, it would have said, as it did under section regulation 34, that if he believes that the matter is sufficient to warrant it being passed up to a higher level than himself because of his sentencing powers and otherwise, it would have said so.
But that's consistent with the may in section 7.
Well,
May
that
gives him a discretion. Obviously, he has to exercise his discretion in accordance with correct legal principle and the like, to act rationally and all that, but that isn't under challenge. We assume he acted rationally for this purpose.
Well, I would say, my lord, that although that is not featured in the papers before you, at the first instance, the claim had been brought, the judicial review had been brought on the basis of unreasonableness of the in addition.
So what happens to
in
that?
addition to illegality, there
So
was
what
a
happens
question.
to that?
Well, can we just look at that? Where is that in your claim form, which is tab 2?
It is at... In the just
Affidavit.
the affidavit, that's what you mean.
But there must be a claim form somewhere, tab 1.
No, there is
There
a
is
claim
a
form.
claim
There is a
form,
claim
tab
form,
1, yes.
and it is tab 1. And in the paragraph 1 of the relief sought is the writ of certiorari. in paragraph 2, a declaration that a decision is illegal, null, and void. So it does not state the unreasonableness in the relief sought. However,
It doesn't actually state any grounds, does it?
no, that's the
Okay.
point. It
Well, there
doesn't
we are.
state any grounds.
All right.
But it is contained in the arguments that were before the first
Well,
instance
can we
court.
look at the affidavit to see the way you put it? And where is there any complaint going beyond the one which appears to be before us? The construction of the regulations.
Ultra vires, paragraph 11. Vires, paragraph 12.
I mean, the whole of this appears to me, if you read it, going on, paragraphs 14, 15, 27, 28, it's all about whether or not there was power or a discretion to refer.
Yeah.
I take that point. I know I've read it in the submissions that were filed before the court, but it's
Well,
not
if you-
actually set out properly in the,
I mean,
in the affidavit.
This litigation is not, of course, a moving target.
Yes.
And we are dealing with the issue which was raised by these proceedings and appears to have been dealt with in the Court of Appeal. If there's something in some other document which changes it, of course, do refer quickly to it, but at the moment I don't see it.
I'm guided, my lord. But I do still say that in relation to the question of exercise of the discretion by the use of the word may in the
Right.
first half of section 7.2, which suggests that there is a broad discretion, that there is nowhere in the code that actually sets out the ambit of that discretion and what
But
may
why do we need to
influence
have
it.
anything in the code to do that? I mean, you have the discretion, and
I think that
That's sufficient, surely.
I think that in the circumstances where we are not in fact dealing with a judicial officer, and that
this is another point which wasn't taken below, though.
well,
I mean,
think
none of
that-
the courts below grapple with the idea that there wasn't enough explanation.
Can we just look
No,
at...
I think that was, my lord, in terms of whether or not he ought to, when we get on to the rule of doubtful penalization, and whether or not at the outset the officer would have appreciated the possibility of being exposed to the ultimate sanction, which is dismissal.
The other side's case is he could work that out by reading the section.
But that's not, I don't think that that is fair, a fair interpretation, or nor does it accord with principles of fairness in terms of disciplinary proceedings against an employee.
Can I ask you, if you are reading this, we've read sections 7.1 and 7.2. Sections 7.3 and 7.4 both start out where the superintendent refers a charge to the governor or where the superintendent does not refer a charge to the governor. Can I just suggest to you, does that not suggest that there is a certain flexibility or discretionary element to whether a charge is referred to or not? I mean, if it had been automatic that it was not referred if it was not serious and was referred if it was serious, you wouldn't have this rather open-ended suggestion that it may or may not happen, and you have to... is that not a problem about your construction?
It is, and I say that it flows from the problem that begins with section 7.
Right.
And
Yeah. When you say it's a problem that flows from, isn't it a problem which suggests a problem about your construction of section 7.2?
well, my lords, I think that I think that even the appellants have conceded that the section 7.2 is open to two interpretations. And I think that once that occurs, once that concession
But
has
is that,
been
is
made,
that a sensible concession?
Yes, I think we saw that there was you cited some statement in argument that maybe these regulations needed rethinking, but it's really for us to make up our minds whether we feel any doubt about what the section was intended to mean.
yeah, that is similar, but also bearing in mind that we've had two courts two panels of judges who have also had some difficulty with the interpretation of it, then that's the reason that we're here is because of that difficulty. So it cannot possibly be.
Well, I don't know, but you have to explain to us what is ambiguous about Section 7, subsection 2. I haven't so far grasped what that is.
Well, my lord, we say that just the structure of the sentence alone, and I've found it very helpful, some of the extracts that have been put forward by my friend from the Thornton, where it breaks down, use of commas and use of modifiers and use of adverbs and so on, to show that this structure of this sentence requires multiple readings in order to sort of understand
Well, why does it do that? It seems quite clear to me at the moment.
You have to add, anyway, we've perhaps been through that. Can I just ask a separate point? Would you look at section 11, subsection 2?
Yeah, what page is it?
It's hard copy 67, I'm sorry.
That's all right.
Section 11, subsection 2, where the superintendent has referred to the governor a charge that he had power to deal with by himself, the governor may remit the case to the superintendent to be dealt with by him. Now, can you help us to the circumstances in which, on your case, the superintendent could refer to the governor a charge which he nonetheless, as an alternative, did have power to deal with by himself?
Well, perhaps one of these very charges that he has referred a charge to him, which because of the nature of the charge, he ought to deal with by himself as the superintendent of the prison.
Well, no, this section can't be contemplating situations where the superintendent has acted illegally. This must be contemplating situations where, as a matter of legal entitlement under these provisions, the superintendent is entitled either to deal with it by himself or to refer it to the governor. On your case, what such situation ever exists?
I've thought about it, my lords, and I can't identify a specific situation, as your lordship has guided me, that the section could not contemplate the superintendent acting illegally or unlawfully, referring a section which he had no authority to do. But that was my thought process, that is a situation where the superintendent has referred a matter which he ought to have dealt with himself.
Yes, sir. So it
wouldn't be.
It's for people, it's for cases where the superintendent has referred a charge which in fact he had no power to refer.
I'm sorry, my lord, I can...
So section 11.2, if you're right, is for the cases where the superintendent has referred a charge but in fact had no power to do so.
Yes, or ought not to have done so.
Well, not ought not, could not.
Could not, yes.
If you're right.
The difficulty from your point of view is that it deals with situations where he did have a power expressly to deal with them by himself.
Exactly.
But again, we go back to the question of looking at it in practical terms. In what circumstance, the circumstances in which the superintendent could refer lesser offences to the governor on the specifically accepted offences under these sections.
The lesser ones, quite, yes.
What would warrant it? We now have to go into speculation. And in fact, that explanatory statement or document which the superintendent in fact sent to the governor does not assist us in any way at all. And it therefore means it's a completely subjective...
No, but hang on, but what you say is meant by, or what falls within, a charge which the superintendent had power to deal with. Well, give us an example of such a...
Well, an example of that, my lord, is section 2, even subsection 2A1, while on duty, while on or off duty, acts in a disorderly manner.
Well, that's a minor case, but
well, that's
on your case, of course, that's a case which can't be referred to the governor.
That's the point that I'm trying to make.
Yes, so then, but on the true construction of section 11.2, give us an example of the kind of case which would be within the superintendent's power.
Well, for example, the
all the minor ones, you say, don't you?
All the minor ones, yes.
Yes, but it obviously doesn't.
Your case depends, doesn't it, on saying that 11.2 is for the cases where the superintendent has referred when in fact he had no legal power to do so.
Yes, ma'am.
In other words, all the minor ones.
Yes, ma'am.
Yes, okay.
Well, the trouble is, how do you deal with that he had power to deal with in subsection 2?
Well, he had power to deal with it.
He had power
Question of whether he had power to refer it. Is
Yes.
what you're- yes.
Yes, I see. Yeah. Yeah. So I think we've got that point. What about other considerations? I mean, you referred to some in your case. You referred to doubtful penalisation a moment ago.
Yes.
I think we understand the idea.
May I just, before we move on to that, with your leave, my lord, just remind you of an example that we've given, and unfortunately, I must apologize, despite our best efforts, we weren't actually able to find the previous iteration of the rule, but this is the Hong Kong Prison Rules 2012, where in section 245, which is on page 76 of the printed bundle, 613 of the electronic bundle.
Hang on.
Yes.
So these are the rules where in Hong Kong.
Hong Kong, just by way of an analogy, where the point we're trying to bring across is that a legislature recognizes the need to expressly provide for a case where the superintendent may have the power to deal with a charge, but he believes that his powers of punishment are inadequate, which is one of the main arguments made by the appellants as being a reason why the superintendent would have referred a lesser offense, a lesser offense to the governor.
And that's in which of the Hong Kong rules? Which number?
245,
Thank
6.
you very much.
245, subsection 6. And it's sort of along the same argument that we've made in relation to Regulation 34 as it relates to the discipline of the prisoners, where an express provision is made that if the superintendent's powers of punishment are considered inadequate for the gravity, perhaps, if it's a repeat case, or if perhaps even though the charge is one of, let us say, insubordinate conduct, it is so egregious that it ought to be dealt with
Yes.
by more severe.
I mean, we understand that one could have spelled out the criteria governing the exercise of any discretion, if there is a discretion. But as my lords have pointed out, if the criteria haven't been spelled out, that isn't necessarily the end of the matter, and there is going to be an explanatory statement of some sort. So we have to approach the matter on that basis.
Yes, just to draw one line under that, my lord, with your leave, is that where the Parliament legislature has in this case made express provision for such a situation in one part of the regulations, but not in this specific part, we ought to read something into that omission of not setting out the criteria, and also to remind your lordships of my point that, in fact, the explanatory statement does not, in fact, give any indication of the basis upon which the superintendent determined that he ought to refer these charges to the government.
I'm not sure about the second one, but just explain that, because that's just a failure of how it worked in this case. But what's your first point? That there is something inconsistent in the regulations?
I think it's page 587, isn't it? It's the reference to powers being inadequate in that other provision.
Yes, my lord. Yes, my lord.
Oh, in 34.1?
Yes, my lord.
Yeah.
And I should also, while we're there, just again to just draw the line under this, is that section 14 of the code itself, for example, where it makes specific provisions as to how the governor is to exercise his powers. Section 14 says, where the superintendent refers a case to the governor, he may suspend from duty the accused officer if, in his opinion, the offense charged is so grave that the officer should not continue in his duty. I just made that point to show that there was consideration and provision for specific exercise of his discretion and what ought to inform
So the he
that.
there is the superintendent, or is it the governor?
It's the superintendent, by my reading.
Yes. Yeah, sorry, what's the point that you make on that?
That the specific express provision has been made for how the discretion is to be exercised. If he refers a matter, if he thinks it is so grave, he may suspend, and that, I think, points out that it is really the serious matters that was contemplated to be referred to the governor, and the exercise of his discretion, if it exists, which we still have an asterisk beside, that he may in those circumstances even go so far as to suspend the officer because the charge is so grave. That was not done in this case. The point here being that time has been taken to make a provision for it in the code, and none has been made as to why he should be referring matters that are lesser offenses to trouble the governor.
Yes?
If I move on now to the question of doubtful penalization.
Well, I think we understand the point that you're making. The whole consequence of reference to the governor is to expose the officer to a different level of sentencing or disciplinary award.
Yes, which at the outset the officer would not be aware of.
Well, I mean, that begs the question. It begs the question as to whether the officer has read the rules in the way you suggest or the way that your opponent suggests.
Well, even if the officer has read the rules in the manner in which the appellant suggests, when the superintendent calls him in, is conducting the hearing, at that point could, I think, safely assume that the superintendent is dealing with these charges, particularly as they are these lesser charges, lesser offences.
If I may say so, that is also circular because it all depends on whether the officer is exposed to having the charges referred to the governor, which is the question. But anyway,
You make a natural justice point, do you? You say that he wasn't aware, or wasn't told at the outset that that was going to be a possible consequence.
That is so, my lord. And
that's at page 17 of your
Does
case.
Anguilla have offences triable either way,
they do.
in which the magistrates may either decide to
Yes.
try summarily or to commit?
Yes, my lord.
And is that an infringement of?
No, because and I'd like to get to that point because in the Magistrate Code of Procedure Act, which Section 45, which is at page
Warning, of course, there.
560 of the electronic bundle. 27 of the printed bundle. It's tab 2 of the authorities.
sorry, what's the section?
Section 45, my lord. So it goes on in section 45.
I think
Subsection-
I think you're giving us electronic references which are 5 higher than they should be.
Oh dear.
It's good for the mental arithmetic. Don't
I
worry.
apologize. But no, the last time I was here, it was the same thing. Luckily, it was by 10, so that was much easier to do. I apologize.
Well, welcome back.
I think
we're doing better, or somebody's doing better.
there must be something with the distance of the seas that's causing our electronic numbering to operate in a different way. In section 45(2), it says the magistrate may, on application by the prosecutor accused or of its own motion, consider whether an offence that's triable either way or to be tried summarily. And then it goes on to say, before so considering, he shall cause a charge to be written down and read to the accused.
Yes.
Sub 3. And then it goes on in 4.
That would be true of the proceedings before the superintendent, but go on,
Yes.
your best point's coming, isn't it?
Yes. And then in 4, sub 4, the magistrate shall in ordinary language explain to the accused the meaning of the offence being dealt with summarily. In other words, here, the meaning of it being dealt with, the effect of it being dealt with by the governor as opposed to the superintendent. And point out to him in F, if tried summarily and convicted by the court, he may be committed for sentence to the High Court. And then in subsection 5, after explaining to the accused, the magistrate shall ask him whether he consents to be tried summarily or wishes to be tried by a jury. So there is a very elaborate and detailed structure to ensure fairness, that the accused is aware, fully aware, of his exposure, and in fact he is asked to make a choice. Or to indicate a choice. So the magistrate may not accept that and may proceed in a different way, but it is all explained, carefully explained.
So what's wrong with our present provision?
That there's no similar provision in the code whereby the officer is explained to him, because the analogy has been made that it's likened to offences triable either way, where it may be tried by the superintendent or it may be tried by the governor. And that's, on the appellant's case, it's simply an election that the superintendent makes on his own. And we said, in order, if you look at the details of if you really, as the Americans say, bottom it out, dig down to the bottom of the analogy that is being made, it is quite the opposite effect in a magistrate's court, where the rules require, for fairness, the accused to be fully informed of the options that he faces prior to the commencement of the proceedings.
Yes, you make a point in paragraph 66 of your case by reference to employment cases. You say that it's important
Yes.
that the employee should know at the outset
Yes.
whether the hearing may end in his dismissal or simply his being disciplined, and you say the same should apply here.
I do. Thank you, my lord. And that is recognizing that this is a statutory provision in England, but it's really just codifying what are natural justice principles.
That again begs the question, doesn't it, whether paragraph 7 of the code means what they say or what you say, because if it means what they say, he does know.
I still maintain, my lord, with respect, that even taking the construction of the appellants, the officer would not know for certain. No. And if we take, for example, the case...
He would know that it might be referred.
He would know that there is a power to refer it.
Yes.
But he wouldn't know, would he know necessarily at that point what the consequence of that referral is?
No one would.
Yes.
No one would. I mean, it depends on the proper exercise of the discretion.
Well, my lords, if I can just use the example of the Zimmer case, which is in the bundle, in which, in that case, the employee, and it was a question of whether or not the employment was unfair by reason of not complying with step 1 of the standard procedure. And in that case, he had been called to a meeting to discuss and review his expenses that he had submitted to the employer. And to that letter inviting him to the meeting, that's at page 355 of the printed bundle, 90, is it 5 plus or 5 minus? 902 of the electronic bundle, I
It's
think.
5 minus, you have to deduct 5.
Thank you.
So we're looking
At Zimmer Limited.
yes, right,
and
which paragraph?
So there,
Which paragraph?
well, I've not got to a specific paragraph. I'm
Oh,
just
I see.
giving an
You're gonna
outline
give us
of
the
the
whole lot.
course. But it's actually paragraph 23, my lords.
Yeah, thank you.
There, the employee had been called to a meeting to discuss and review his expense charts that he had submitted to the employer for reimbursement for traveling on business. And to that letter inviting him to the meeting, the disciplinary policy had been attached. The court held there that it was not sufficient that it was implicit, or that he could have, if he read the disciplinary policy, understood that he could have faced dismissal, which is, to my view...
This is presumably at the substantive hearing when...
No, it's not. It was not even at the substantive hearing. This is at the preliminary hearing. The very outset of the disciplinary proceedings.
Sort of general natural justice point.
Yes, my lord.
But here all he had to do is to read the section and the consequences which are set out in the next section.
Well, I think that, my lord, in terms of, if we have, looking at this case, this scenario, both in the Zimmer case and in the Cartwright versus King's College of London case, where the courts have found that it is not sufficient, that it is implicit in correspondence that there is a possibility of dismissal, that it must be stated,
well, wait a minute.
In all fairness.
Isn't there a statutory rule which directs what advance
Yes.
notice has to be given? It's referred to, unless I've misread it, which I expect I have, in Zimmer, as step one.
Yes, my lord.
That's a statutory requirement, is it?
Yes, I accept that.
So we haven't got that here.
No, I accept that, my lord, but I say that that statutory requirement is really codifying the principles of natural justice.
Yes, I see.
And that the same thing ought to obtain here, where the prison officer, if we cannot presume or take it as given that if he read the section, he would have understood that the possibility of it being referred to the governor, and that with that possibility, there was a possibility that he would be dismissed. He needed to be told that in clear terms at the outset. Same too in the Cartwright case. In Cartwright, it was even, you would think, clearer, because in fact, the correspondence between the employee and the employer were repeatedly referring to the fact that his employment may come to an end if they were unable to find alternate employment for him and so on. And nevertheless, notwithstanding that in those circumstances, the court ruled that it was not sufficient for there to, you must make it quite plain and clear to the employee of the possibility of dismissal as a result of the disciplinary procedures.
But, I mean, we haven't got much about the facts of this case, but...
Which one, my lord?
Sorry, we haven't got much about the facts of the present case.
I see.
The proceedings, the hearing of the charges, the hearing of the evidence, apparently lasted about 5 months.
Well,
Or began in or around August and continued down to the latter part of 2012. Was your client represented by counsel then?
no, he wasn't, my lord.
Had he taken... We haven't a clue what course the proceedings took or whether he was advised. He doesn't say he wasn't advised, but...
And similarly, the superintendent doesn't say he was advised.
No, but they don't have to deal with points which haven't been raised. You weren't complaining at that stage. It may well be standard procedure to put those who are being disciplined on notice of what the course of events may be, in which case there can be no natural justice complaint, one would have thought, in the particular case.
I mean, I don't think the natural justice point has been taken before, has it? I mean, in your pre-action protocol letter on page 34 of the record, you set out the complaints you're making, and I don't think there was a natural justice point there.
No, it had not been, and the officer himself had written a letter in which he raised different natural justice points.
Well, he
but not
raised
that.
a point which
Yes.
might have justified the superintendent in thinking that he ought not to hear it.
Yes.
He raised the suggestion that the superintendent was being judged in his own cause, didn't he?
Yes, he did.
But I mean, do you agree? Because if we've missed it, we must know. From what I've been able to find, the entire case has proceeded until today on the question of construction and ultra vires alone.
No, in the Court of Appeal, the appellants did raise the natural justice points.
But only in the Court of Appeal.
Pardon, my lord?
Only in the Court of Appeal.
Yes.
Not originally or before the judge.
And what did the Court of Appeal say about them?
I'm just getting the guidance. I was not in the matter before.
No, of course
now.
not, no.
There's a counter notice in the Court of Appeal, isn't there, on page 181, which raises the number of points. I'm not sure it raises this one, but it does raise various points.
181
Of the hard copy, I don't know about the tab,
of the record, yes.
tab 9 of the second volume of the record.
No, this tab bundle 2. Bundle 2.
It has a number of different grounds for upholding the decision,
Yes, my lord.
but not, I think, the natural justice one.
No, it's not there.
And as I say, the appellants did raise natural justice points in the Court of
But
Appeal,
where?
but that was not
Where
the
do
court
we see this?
in the natural justice points, my lord?
Yes.
In their submissions.
Where?
Oh, I'm sorry.
We've got the transcript.
I'm sorry.
You can show
It's not dealt with at all in oral arguments, and the Court of
Not
Appeal
dealt
did
with in
not.
the written submission.
But in
All
the
this.
in the written submissions, my lord, it is at page paragraph 57, page 224.
Thank you very much.
Page what?
224.
Hard
That's the hard
copy.
copy, is it? Sorry, that's the electronic copy, is it?
No, that's the hard.
No, I think
It's
that's
hard copy, okay, 224. Right.
What, paragraph 62?
Paragraph 62, yes or no?
Let's just see.
And starting from 57.
Page 371 of the copy.
371, that's more than
Good
five.
PC says that the third logical consequence that I would submit is in relation to the incorporation of natural justice.
Sorry, what paragraph?
This is really dealing
Page
with the question of judging his
371.
own cause.
371
Paragraph?
in the,
It's not a paragraph, it's line 13 on page 371.
In
Oh,
the,
Those
page
who
of the
have
other
the
224,
electronic copy.
and what is the document?
No, 371
It's
is
the
the...
submission of counsel on behalf of the appellant.
So your original, what was the original number you gave us?
224 of the printed bundle, my lord? 224 of the printed bundle. These are... Oh, I'm sorry.
no, but this is, the point here being made is that what the judge says,
And 190.
if the situation has no discretion to refer, if the superintendent has no discretion to refer, it may well be that he may be hearing a matter in his own cause which breaches natural justice. That's the judge putting it to Mr. Kentridge. And then Judge Michel says, that wouldn't help because the superintendent is anyway involved in hearing the evidence, so it wouldn't solve that problem. That's not a natural justice point that you're raising.
No, this is the one about judging own cause. But
This is a construction point, isn't
Yeah.
it? This
Yes.
is, if you don't construe it our way, you may end up with.
And it sort of
Breach
is
of natural
subsumed in the doubtful penalization argument that it would not be clear what penalty he's facing from the reading of the section. That is at paragraph, where is that in the Court of Appeal?
And why would it not be clear?
Because it doesn't set out the circumstances at all in which the superintendent would refer it to the governor, or nor is there any requirement for that to be stated to and I'm adding to that, nor is there any requirement for the superintendent to make that plain to the officer as he is conducting the hearing. Prior to conducting the hearing, during the course of, none of that has ever occurred.
But this point of natural justice has never been raised before the Court of Appeal or the first instance judge. This particular species of
No,
natural...
the natural justice point here raised is the construction argument, which we discussed earlier, and it's an answer to that one.
Yeah.
It's nothing to do with the present natural justice point,
No.
which is a different one.
Yeah.
So where do we go?
But Lords, would you accept that?
We've got the point, I think, anyway.
Yes.
Good Oriole.
No, but would you accept that as we are here concerned with the construction of the section, that notwithstanding the fact that that point was not raised in the court below, that your lordships are fully able to address it? There's no issues of fact or so on that would influence
Well, I just
the fairness.
wonder about that. I just wonder about that because we don't know what took place before the superintendent. We don't know whether he gave the warning.
I think we do know, based on the fact that Mr. Gums, the superintendent, in his affidavit sets out chronologically what he did.
Well, I know, but he's not. Just show us that. Where is it?
It's at page 41 of the printed
I've got it.
bundle.
That's right.
And then where he is rehearsing, paragraph 15, he says, well, before that,
He says, where I believe the circumstances
Yes.
justify a more stringent award, I may impose, the court code gives me power to refer, that's paragraph 14. And he says, I exercise my power under section 2.
prior to that, my lord, in paragraph 5, he said, so the dates on which the charges were delivered to the deputy superintendent, and that he acknowledged receipt of them.
I think the point is this, Small Davis, that this was not an issue before the first instance judge or the Court of Appeal. If it had been raised as an issue, one might have expected that it would have been dealt with in averments contained in the affidavit. The absence of any averments may be explicable either because it wasn't said to your client or because it was not perceived to be an issue. We can't now fill the evidential gap that exists.
I take the point, my lord. But may I deal with another point while I'm thinking about that?
Yes.
A good answer to that.
You've done terribly well so far for this issue, for my part.
What other points are there to take?
Just checking. I'm just checking here with them. I can't.
I mean, there's been we haven't got any of the factual material, have we? Part of the trouble. I mean, the factual
some.
material was considered over about, as my lord said, over a month.
Over 4 or 5 months. Now, I suggest we give you a moment to think about that in the back of your mind while you think about whether there are any other points that you need to develop on your written case.
Just to answer my Lord Clark's query, in fact, in the superintendent's affidavit at page 42 of the printed bundle,
Yep.
he does say in paragraph 8 that he heard the evidence on various dates over the period.
Yes,
Yeah.
But
exactly.
it doesn't indicate how many
Well, I
dates.
see it is a
or
bit
so.
shorter than I thought
Yeah.
in the other document.
It's actually within the space of a
All right.
month.
But
Yeah,
an
it
awful
doesn't-
lot
it doesn't
can
matter.
happen in a month. And
Yeah.
the basic point is that this aspect hasn't been investigated.
I mean, thinking about it, I do accept that it would not have been at the front of the party's mind, and certainly perhaps not the superintendent's mind, in terms of, making any representation as to whether or not he informed Mr. Hamilton of the possibility of the matter being referring and the possibility, therefore, of his being dismissed at the end of the day if it is dealt with by the governor. However, I think that it still is unfortunate because I think it is an important point dealing with the natural justice principles and the requirement to make it plain. I do think that it perhaps could somewhat be drawn under the doubtful penalization points that we make. And I don't know if I can take it any further than that.
No, I would think so wrong. It's not a bad point.
See, we've got an affidavit from him, Ms. Small-Davies. The one thing he doesn't say is, I had no idea this was a danger.
No, well,
Yeah. So I think really we're all of the view that this is not a point which is strictly open to you, but even if it were, there isn't the material on which you could use to make any bricks out of it.
yeah.
But you are entitled to say, as I think you do, that your construction is right because it carries less risk
Yes.
of the system giving rise to a breach of natural justice than theirs does.
Thank you very much. Well, yes, and I think that Mr. Justice Michel in the Court of Appeal did say a few words in connection with that.
Well, I think it was on a slightly different point, actually.
Yes.
Now,
Yes.
what more is there to be said?
I can't think of any other points which I need to bring to your Lordship's attention. I'm grateful. No, well, and I think your Lordships have the point about the rule against absurdity, the interpretation that both the clause in the beginning saying shall refer all charges, refer certain charges, meanwhile being given a blanket discretion to refer any charge. The point of there being possibility in that construction of the superintendent referring every charge he feels like just on his subjective view, that creates an administrative unworkability. In the Benyon refers to a case in which the similar conclusion had been drawn by the House in relation to the interpretation of the Income Tax Act and the impracticalities that it would have caused to the commissioners to put that into effect. So that there is a difficulty from our point of view that it results in an illogical result whereby the governor might find himself having all matters, any charge, including these lesser offences having to do with coming late for work.
Send it back, though, the governor.
Yes, he can.
I mean, one of the features of this case is that nobody complains about anything the governor did. It's the fact that the governor came on the scene at all, which you're complaining about.
Yes,
Yeah.
mainly, yes. Yeah.
And of course, the discretion has to be exercised in a reasonable manner. I mean, sending every trivial offence to the governor would plainly be out of step with the interpretation advanced by the appellant.
It would definitely, I think it would most definitely be so. Because it doesn't say Thank you, my lords.
Well, thank you very much, and I apologise at the outset for referring to you by the wrong name.
That's
because, in fact, on our sheet, your name appears second. But thank you very much, Ms. Small-Davies.
Thank you very much.
Mr. Kentish, is there anything you want to add?
Not at all, my lords.
Thank you very much indeed. Then I think we'll take a moment to think about where we are and just retire briefly. Yes, Ms. Small-Davies and Mr. Jones, we don't, I think, need to trouble you, Mr. Jones.
I'm extremely grateful, my lord. There are 2 points of clarification purely that may assist. They're not submissions.
Well, they will be submissions, and if you wish to make them, then obviously Ms. Small-Davies will have a right to reply to them.
My lord, I'm grateful. They're simply this. In relation to the letter that was referred to at volume 1 of the record at page 52 regarding the background and conduct of Mr. Hamilton, that has been read hitherto by the board and by Ms. Small-Davies as the explanatory statement for the purposes of section 10, subsection 1 of the code. My lords, I do invite consideration of section 10, subsection 2 of the code, which states that in any case where the accused officer admits the charge or not, the superintendent shall forward a report on his general character and efficiency. My Lord, simply to make the point, we don't know for sure, but it appears that that letter may well be a general report on his character and efficiency rather than an explanatory statement for the purposes of 10.1.
Yes, I see.
And,
right.
My Lord, the second point is this, just on the natural justice point, which I know the board has considered thoroughly. It is this. Again, my Lords have section 12, subsection 2 and 3 of the Code. Subsection 2, that's page 68 of the authorities bundle. Where the governor proposes to make an award under subsection 12.1 A, B, C or D, he shall give notice to that effect to the accused officer. My Lords, those are the more serious sanctions of dismissal, etc. Subsection 3, where an officer is given notice as aforesaid, he shall have the right of a personal hearing before a person suitably qualified, other than the person who held any inquiry under section 11 of this code. At this hearing, the officer may be accompanied by any serving officer of the prison service. Any request for this hearing shall be made within 7 days of the officer being given notice as aforesaid. My Lord, there is therefore some notice required under the code in relation to the sanctions that may be applied, my Lords.
I mean, we still face the same difficulty. We don't have any direct evidence.
Well, my Lords, we do have...
And I think that my Lord presiding has indicated that this is not an argument available to the respondent. So I think
I'm grateful.
So we've heard what you say, and we noted it.
Well, my Lord, I'm grateful. It's simply to say that we complied with those sections.
Thank you very much.
I'm grateful.
Yes. Is there anything arising out of that, Ms. Small-Davies? Thank you very much indeed. Well, the board is grateful for the forceful and helpful way in which the submissions have been put, both in writing and orally today, and will take time to consider what advice it will humbly tender to Her Majesty.